Welcome to the recording of our Staying Ahead of the DC Rental Market Legal and Legislative Insights for Independent Landlords. We held this webinar earlier, and unfortunately, we had a technical difficulty that did not record the first 15 minutes. So I wanted to just share a brief overview of what we in fact covered, because this is our 12th and final webinar of the year. We found it a fitting wrap up of the year and start looking into 2026, as I hope many will be able to take the next couple of weeks and enjoy some time off and with the family. And we will have a Q&A at the tail end that you should be able to stick around for, because we did get the overwhelming majority of the webinar recorded. It just was the first few slides. So my name is Conrad Bennett. I am a realtor, property manager, and for over 25 years have been helping independent landlords in this city be able to provide housing to renters. I am not an attorney, but through my experience, we are able to give great guidance to our clients. With that said, we have Brian Dorwin with us as an opportunity for us to collaborate with, and a great resource for us, because we've worked together for many of those years. And even when we're out of the office, we're likely talking about stuff like this. So it's great to be able to have him this fall. Now, the reason that we did this is because 2025 was significant. Obviously, in a very highly regulated market that is very tenant friendly with a lot of oversight, it's critical to be able to remain up to speed on the legislation that is in fact coming down the pipeline, and some of which is soon to be implemented. And so our small landlords, the independent housing providers, are the ones that generally face the most risk with compliance. And we want to make sure that we are covering you. It did bring a lot of reform. And so with the overview of the Mayor's Rental Act, which was huge news in 2025, probably only overshadowed by the conversations about the RFK and the commanders returning to the district. But there are huge takeaways about protecting public safety and accelerating evictions, and the emergency rental assistance reform. So ERAP, the programs that provide tenants with some funding when they are in need. The eviction reform, and then the protective orders, all of which were covered and will be expanded upon in a little bit. Here's where we were able to catch the recording, and I hope you enjoy. And then along those lines, we always suggest taking action sooner than later. Owners will say, oh, I'm going to wait another week. I'm going to wait another month. You know, they've usually come good. But obviously, we just went through the government shutdown, and quite frankly, that is a possibility of happening again. And we always want to stay ahead of the curve, because quite frankly, the time and energy to get the ball rolling is well worth the potential return. I mean, most owners, I think on average are charging, $2,400-$2,500 a month on average across the city. So a couple $100 for a filing fee is well worth getting your spot in line. And one part of that we also like to talk about is the fact that if tenants take action against you, right? And this is something we're going to talk about a little later in terms of the maintenance of the property. But if you want to be the first in line, right, with these filings, and get going, because there are some portions of what we'll talk about in a little bit about, the condition of the property being maintained, and the tenant saying, hey, this wasn't taken care of. And it could be something insignificant in the grand scheme of things, but it could have a big impact on the timelines and expectations there.
Absolutely. And if a tenant calls the Department of Buildings without telling you, right before you issue that notice, then you've got a presumption of retaliation to deal with, right?
Yeah.
So
yeah.
It is important to get the process started. Yeah.
Get the process started. And just to go back to that, because I will talk about the next, it doesn't take much for a tenant to reach out to the District of Columbia, right?
Super easy. Yeah.
And I've just was talking to another owner the other day where they're like, they didn't even report these issues to me, right? And so it's important, and we'll expand upon it later, about knowing what's going on, having eyes on it, and doing pre-inspections to confirm that you know the status of the property and attend to these issues. And that's something we'll expand upon in a little bit. You got to be proactive, not reactive. So if we do the pre-qualifications, we already know what needs to get done, and you are going to be filing for suit. What's the timeline between the initial notice to filing? I mean, I know that we've alluded to it being accelerated, but if once you file, once you get a court date set, or actually rather phrase it, once you set a request for a court date, how long are you seeing before court dates are being coming around?
Your initial hearing is typically going to be, at least another month and a half, sometimes 2 months to get into the initial hearing. And that while that may not sound like much, remember we've already said 2 months of rent are due. So now you've got 4 before you ever see the inside of a courtroom. And I think what's important to know, and your point about preventative maintenance is well taken. Nothing really happens on the initial hearing date. If the tenant shows up and disputes the case, you're not going to be putting on evidence at that hearing. There's no opportunity to testify. Clients will say, they alleged housing code violations, but I was in there last week and I didn't see anything. How in the world did the court continue this out for trial? And what I have to tell them is because it's an issue of fact, and the court doesn't resolve factual disputes at the initial hearing dates. It's basically an opportunity for everyone to show up and determine whether the case is going to be contested, and many of them are. I'd say most of them at the initial hearing date. So. You put together the complaint. Obviously, one thing that's not on the slide. You really want to make sure that your rent registry information is up to date, formerly the RAD, Rental Accommodations Division form. You want to make sure you've got that. You really want to make sure you've got your BBL, because what Conrad and I will tell you if your BBL is expired is you've got to renew that before we can do anything. And that requirement will not change with the Rental Act. So being proactive about those inspections, making sure that your BBL is current, that's the first stumbling block. And I think probably the most common among small landlords, because it's not intuitive. Unless you're attending these webinars, there might not really be a reason to know that you had to have BBL renewed. They expire generally every 2 years, I think. And so, if you're already 2 months behind, and then right out of the gate you're waiting for a BBL inspection or a BBL renewal to come through, you could be looking at 4, 5, 6 months of rent missing before you ever get to court. Just by operation of that timeline. So that's a really long answer to your question, Conrad, but I kind of want to make sure we're gaming out, how things go if you don't have everything, buttoned up ahead of time.
And you got to, I mean, in this day and age, and I can allude to the conversation about the BBL taking several weeks on its own right. And so if you start to compile this, because one of the next slides is about how long does this generally take, big picture item. But I mean, any of these little infractions or missteps in the process is going to add to the stress and the oversight. And the basic business licenses right now, I mean, in theory, it takes a couple of weeks to be able to get the inspection completed by DC, then another week or so to get the application done, and then another couple of weeks to get the rent registry finished. And there is an aspect of that which we're going to also talk about. In fact, that the rent registry is so backed up, I don't know when they'll be able to finish their backlog. But all of these things, you want to make sure you have your ducks in a row, because any of these missteps is going to add time and still have that potential of getting your case kicked out, I guess, in theory, right?
Absolutely.
Yeah, and so making sure that you have everything, and we'll talk about this, but you want to make sure you also serve your tenant, right? They need to be made aware of the upcoming court case, and there's extra expectations there too, right? It's not just sending them an email and a text message. You're going to have to serve.
We're using a private process server to do that. So they run out and then they have to file an affidavit with the court demonstrating that the service was achieved.
Yeah. And what are you seeing in terms of the number of notices received, and what is the backup plan if they aren't able to personally serve the tenant?
So, my office typically coordinates service. So if there's an issue, if it's a, small building with a front door, they'll coordinate with getting in. I will say, my office has a number of process service vendors, because they've got to keep up with the high volume, given that, the notices of past due rent became a thing a few years ago. It can take, we like it to get done within a week. Sometimes it can take longer than that, depending on the time of year and the availability of servers. But, I think what people have to remember is that service of process in DC can be a tough job. A lot of people did not want to comply with, these companies didn't necessarily want to go through the process of figuring out how to print 50-page packages for every single tenant and take photos and maintain all that data. So, it's tough to find process servers. We think we've got a good group now, but we all are relying on a third party to get that done. So, we stay on top of them, but it's like one more thing that has to happen before you can get into court, and one more opportunity for delay, which is, I think why we keep going back to don't delay, just start the process, right?
Yep.
You want to talk about the timeline next?
Of course, that's the next one on the cycle. So, doing everything right. Let's avoid the potential missteps, because we know that we're working always with our clients to make sure that they've gotten all of that back and behind the scenes stuff done and out of the way before we run into a problem. But if all was in good order, what do you, beginning to end? I'm talking straight through to the U.S. Marshals. What are we we're looking at these days?
Yeah, so we talked about how it can take, from not the first instance of non-payment, you might have 4 months of rent on the street before you ever get to court. What happens next really depends on the parties, and it depends largely on the tenant, right? With let's assume that there's going to be a contested case with no jury demand that winds up going to trial. I think at the last time we did this, Conrad, earlier in the year, I had said that my team had already had our holiday out of office plans set. There are 10 of us, and we have to make sure that, people get at least some time off. And we had already figured that out back in February. That's because we were having trial dates set now. Unfortunately, I have to report that my team has now worked out all of our summer out of office to make sure that we've got coverage for court, because we're seeing trial dates in July of 2026. So, if at the initial hearing you're told, the earliest available trial date is in July, you've really got to steel yourself for a potentially drawn out process. Now, going back to settlement, we want cases to resolve in an enforceable way. We want the tenants to have the right to stay and pay over time if they have to. We want our clients to have a right to come back to court, kind of on an expedited basis if the tenant doesn't keep up with their end of the settlement. But setting aside the possibility of settlement, which you can do at any point, and as soon as right after the case is filed, you could do it before the initial hearing date. It used to be that we'd be in person in court every day settling hundreds of cases, but that's really not an option anymore with the remote hearing environment. So going from, non-payment of rent all the way through getting keys, I think my best estimate right now is that it takes 18 to 24 months. So it could easily be 2 years between that tenant failing to pay and you actually having keys back in your hand. Again, there's a lot of different ways that this can go. A jury demand can make that longer. A missed protective order payment into the registry can make it, shorter. But it is potentially a lengthy process and potentially disastrous for a lot of small landlords. I mean, I deal with landlords all the time who, are not a large corporation that can absorb these losses. And I think what the industry has shown and what the city council has acknowledged is that kind of timeline, even the corporate landlords, cannot absorb years of unpaid rent. And that's part of what the Rental Act sought to address. But 18 to 24 months, I think, is a safe bet. I don't know that it's going to improve much in 2026. I think things like protective orders, things like the technical issues, I think that will help. I don't know that it's going to, I'm not going to sit here and tell anybody that once the Rental Act passes, we're going to be back to 2019, because it's just not, that's not how this is going to play out.
Well, there's an importance to crossing T's, dotting I's, and so much can be done proactively on the front end so that this becomes the exception to the rule, right? I mean, we have to prepare for the worst, but obviously hope for the best. And taking that mentality goes into a lot of what we do, and being proactive and being able to manage the tenants and making sure that we catch these things before they start to snowball. Because so many owners that are looking for an attorney after their tenants have been 8 months in arrears is not exactly going to make for a fun experience as a landlord in this city. But we want to touch on what you should and cannot do, right? Self-help evictions. If you're not familiar with the phrase, don't attempt to change the locks. Don't remove their stuff. Don't shut off utilities. Don't push the tenant out. This is illegal in DC and can make matters significantly worse. Anything to expand upon that, or is that pretty, at least self-explanatory from our perspective?
About as cut and dry as it gets. Can't do it. I see the skip proper notice procedure. We talked about that. You wind up waiting a few months, you get to court, and on day one your case is tossed out. Obviously, I think the two most important things on this are that may be less obvious, were the registration requirements we talked about and deferred maintenance. I mean, it is, I know, difficult, particularly for smaller individual landlords when you're not getting paid and you have to make repairs. But the best offense is a good defense here. And the first thing that a tenant will say is that my landlord knew about this issue and didn't address it. Gotta let EJF know. Gotta get a contractor out there, coordinate these repairs early and often, and take a look at the place, as a preventative maintenance inspection. Conrad, I'm sure you guys do preventative maintenance work for those who need it, and that will become exceedingly important on the day of trial.
And staying one step ahead, because it's not just whether or not your tenant had brought it to your attention, right? Because the judges are going to ask, hey, is there any repairs that haven't been attended to? The answer is going to be resoundingly yes, right? And whether or not you knew about it or not might not have an impact on how the protective order is potentially set, right? The judge could, at their discretion, say, well, instead of paying this, we might pay that, right? And we don't want that to become problematic. And so it is critical to attend to any issues that they bring up. I would even venture to say it's even just as important to be able to get in, put eyes on the condition of the property, make sure and document what you saw during that inspection so that it doesn't miraculously break within 3 days, 5 days, 10 days, whenever that court hearing happens, because a leaky faucet doesn't necessarily develop by tomorrow, right? The toilets shouldn't necessarily be jammed without any inappropriate usage. And so just making sure that everything was working as it's designed, everything's in good working order, that'll help you with that. So don't defer on the maintenance. Make sure that you are keeping it up, because their non-payment doesn't allow you as a landlord to not take care of the place. Right? Two separate and equal. And don't wait till it's too late. You got to be proactive. And when I say don't wait too late, I mean, if a tenant has fallen behind on rent, don't give them more time to see if they can square it away. Don't reach out to a company like us once they are so far in arrears that it's almost an impossible task. Don't avoid getting in to take care of things, or like I said, ignoring the registration requirements, because it just compounds the stress and anxiety associated with going through it when it's beginning to hit your pockets. Right?
We certainly don't like being in court for the first time and hearing that, the first time the landlord came in to address something was the day before. Tenant will say, they came in yesterday for the first time. I've been asking for 6 months, and that's just a less than ideal thing for your attorney to have to hear standing in court in front of the judge.
Yeah, and many individual owners just don't have the bandwidth and or the support staff, the maintenance teams, the coordination, the capacity to get in. Heck, I've had owners ask us to take over management. They don't even have keys to provide us, right? Might not have been in the property for 2 years. And so it's critical to know in this day and age, and that's something that we strive to deliver upon. So that's the negative. Let's look at the positive. I mean, obviously, you got to document everything, right? You got to track the payments when they're received, how it's applied. You got to track your communication. If a tenant reports something, it's not long ago. the calls come in and you take a message, obviously now through our tenant portals or through the email correspondence or text messaging, there's many more means for communication. Track it, right? You need to work towards those attempts at your resolution. So if you're trying to get into resolve something and the tenant is barring access, you got to document it, right? And that can help you with the conversations that the attorneys will have when those days come, or when if you were to go that route on your own, be able to provide to the courts. Serve your notices correctly. You got to cross T's, dot I's. You got to do it appropriately, because as Brian alluded to, there's certainly the capacity for it to be kicked out day one, right? You can't necessarily have a court date and not tell the tenant that date is coming, or rely upon them just finding out through other measures. Consult an attorney early. I mean, we have these conversations pretty regularly, and I know that when we have something that is evolving, we're able to get direction pretty quickly and be able to give guidance and take action, right? Like I said earlier, in the don't wait until it's too late, and you're going to have to figure out a way to start swimming back upstream. And do prepare for delays, right? As much as we want to make sure that owners avoid this altogether, when it goes awry, you got to make sure that you're financially prepared for the possibility. And for all those owners that are expecting the rent come in to pay that mortgage, you need to have money set aside to make sure that you have that covered, right? Don't want to make sure that one thing turns into another situation. Anything worth expanding upon there?
I think you nailed it.
All right. Well, then here's a little checklist that we kind of put together for all owners. I mean, it's useful to audit your property. Make sure that you go through and have everything. Make sure that your leases are up to date and that you've given the appropriate notices. If you're going to do rent increases or adjustments, you got to make sure T's are crossed, I's are dotted. If your property is subject to rent control, make sure that it's filed correctly and everything is in order. You got to go through and make sure that the licensing is up to date. And for any owner that's not sure, we've been doing a property health check for a lot of owners just to make sure that everything is accurate. I mean, I just talked to an owner the other day that used GTP to draft a lease. I can't say that it was anywhere close to what we're used to using in the District of Columbia, and I don't even know what jurisdiction it would have pulled from, but I would recommend using standard terms, standard leases, and standard contracts, specifically in the District of Columbia and any other local jurisdiction. Make sure you're up to date on the maintenance. If you haven't been in your property for the last 2, 3, 4 years, ignorance is not bliss in this environment, right? You got to know what's going on. You got to be able to put eyes on it and work towards it. And of course, we've talked about payment plans plenty over the years. I mean, quite frankly, if a tenant's willing to enter into some form of a payment plan that we can have the courts recognize, that's always going to be in our better interest because of the length of time that can potentially transpire here, right? If you're able to come up with an agreement where they pay an extra $1,000, $2,000, whatever it may be, to be able to catch up in, what would you say, 6 months?
Sure. Whatever, I really think it makes sense to do whatever both parties can live with, right? I mean, if it's something you're willing to do, even if it's going to take a very long time, I still think it makes sense because, simple reason being the monthly rent coming due still has to be paid during that time, right? So again, we're all, housing providers here. We're not necessarily in the business of evicting people. And I'm sure I talk myself out of business all the time over this, but I think it's best for my client's bottom line to get a plan in place and let that person pay over time. It's best for the tenant. It's best for the landlord. I mean, it's, going through the process and securing an eviction is lengthy. It's expensive. And at the end, you're rewarded with an empty unit that, you then have to find another tenant for.
Yep. And of course, companies like us are going to help navigate all of these challenges that you could potentially run. And we can advise appropriately based on the situation. But in theory, we want to be able to treat all of them exactly the same. And our recommendations are going to be taking action early as possible. Make sure that we have everything accounted for and tracked That way it makes what we provide to the attorneys and then to the courts much more clean, and able to be pushed through as quickly as possible when it becomes necessary. And then, of course, follow us for updates. There's a lot of legislation coming down the pipeline, which we're going to talk about more of, but we're constantly monitoring. We're verifying what it needs to get done. We're double checking and getting our advice from legal counsel. Our team talks about these things regularly, going through the implementation, and then, of course, education, protecting. I mean, ultimately, the way that we're focused is to make sure everybody is in the know. There's not a lot of heavy lifting when we're in place, not as much as when you're going to be doing this yourself. But we are tracking all of this for our clients to be able to make an impact and make management of a property in the District of Columbia much more easy. Now, that's an easy transition to what else we got coming up. And I see the questions coming in, and I'm definitely going to be able to expand upon a few of these. But there's a few things that are coming down the pipeline that has been brought up since we had Sean on the last presentation, which you can find in our Owners Learning Center. But Councilmember Pinto brought up a Tenant Screening Amendment Act of 2025, which would allow tenants to purchase their screening report and reuse it when applying for housing. I've already put in my opinion of how problematic this could potentially be. But from your perspective, Brian, what do you see? I mean, the idea of a tenant being able to pull their own credit report and share it, I feel as if it could be an administrative nightmare to all landlords if they leave this at a broad stroke.
I absolutely agree. I mean, the parameters for who you approve will change from place to place, and frankly, it feels like solving for a problem that doesn't exist, which is sort of common, right? I suppose the problem that they're trying to address is the $50 application fee that's being charged, and if you apply for a bunch of different places, you're going to pay that fee over and over again. One thing that I see about this is rental fraud, and it's probably not something we've talked about before, but it is prolific in the District of Columbia, and that applies to landlords of all sizes, particularly those that don't have as robust a screening process, right, as some of the larger corporate landlords. So if you can fire off 50 applications to 50 different places using the same report without paying any fees, I think it becomes a lot easier to get into a unit using a stolen or fabricated identity. And maybe I sound like a conspiracy theorist, but I promise you, every week in my inbox, here's an email from somebody that lives in Oklahoma saying, "I've never rented a unit. Why are you suing me?" And I'm like, "Oh, here we go again. This is a stolen identity." So I think there would be issues there. Not to mention, again, rental screening is already very heavily regulated. There's very clear guidance, very clear requirements, which are often litigated in the Office of Human Rights, about what you can and can't do when you're screening an applicant. And so that's why I say I think it feels like we're solving for a problem that doesn't exist. But obviously I don't have a good read myself as to where this one's going to go in 2026, but certainly something to keep an eye on.
Yeah, and we've already provided feedback and rationale so that as some of these council members begin to just throw more and more legislation out there and I guess kind of see what will stick in theory, right? Like we wanted to make sure that we gave our feedback on this one because it will become an administrative nightmare. It will become extremely problematic. And of course, at the same time, there's administrative expenses associated with running an application. It's not just necessarily that application fee, which they did a few years back, cap, right? And it sometimes will barely cover the cost. And they didn't even expand upon the fact that we still have to run criminal separate from credit, right? And so there will be issues there, and we're going to continue to monitor it. The extension of the Emergency Amendment Act, this is related to the Rent Registry, which we talked about earlier, because they didn't necessarily have the time to be able to fully implement. But at the same time, that deadline has come and gone at November 30th. For those that have not maintained compliance and gotten the paperwork in, I highly recommend that you get it going. And if you are in a position where you have the next couple of weeks off, I would probably say roll up the sleeves and get it done, so that you don't have to have any of these conversations that Brian and I have been expanding upon during this webinar, right? The like rental stabilization clarification, this bill is going to clarify rental unit participating in the low income housing tax credit program are exempt from rent control. But then the next one is also going to be about voucher holders, and the limit set of being in line with the rent stabilized housing. So in theory, when you have properties that, and I got to say with the rent registry, you need to make sure that you are filed as exempt from rent control based on certain requirements. If you don't, in theory, you're going to be subject to. And so some of these do have impacts. While everybody might look at this and be like, well, that doesn't apply to me, it doesn't apply to me. I don't want you to be found subject to some of these potential challenges.
Right. First, if you don't assume that you have the small landlord exemption, because unless you're on file with the city the right way, you are subject to rent control too.
Yeah. Right. And that's a whole lot more paperwork than most of you will want to handle. And so do the front end paperwork so that you don't have the back end headache. So this is always the fun part that we also expand upon and talk about pretty regularly as far as judge appointments. I know that they're federally posted positions. I've heard a handful of numbers, but we do recognize that overall the court delays are also related to the volume of inquiries and requests and the judges that can hear the cases, right? So that has become a potential challenge with the delays that we'd mentioned. And this is just one that I'm continuing to monitor, but we all have heard the evictions not being allowed if it's too wet or if it's too cold, and now there's potential legislation that would prohibit evictions if it's going to be over 95 degrees, right? Now, with the eviction, you don't necessarily, we aren't putting prisoners' possessions out on the curb any longer. There is the act that held us lock up the doors so that everything is kept inside and then obviously has to be removed later. The tenants have the capacity to get in and attend to it. But the weather certainly does have an impact on whether or not those U.S. Marshals will be able to do it. So we have opposed this legislation because if you start looking at the weather in the district of whether or not it's going to be too cold, too hot, too rainy, what have you, closes out the window of opportunity to actually get to that point when you do get to that point, right? And we did want to talk about briefly the fact that this is going to be a very big election year. And Brian, you said earlier that 2025 was exhaustive. Think about if some of these council members step down. We have the mayor's race. There's a potential for the delegate on the Hill. And some of those council members are going to be looking to fulfill that position and run for it. And so there is going to be a lot of legislation that we anticipate going into 2026 as some of the shuffle starts to occur, right?
Absolutely. Yeah. I don't think we've had, it feels like we haven't had this many vacancies since I've been monitoring DC Council. I mean, there's going to be a lot of change. Obviously, there are a lot of question marks in who will be leading the city, going forward. And, look, all I'd say on this point is try to stay informed. If you're voting based upon your personal preferences or political persuasions, keep an eye on how people vote on bills that impact your business. I think it's worthwhile to know. If you're voting in Ward 4, it's worth it to know what that person has said or done about small independent landlords. So keep it in mind when you go to the ballot box.
And we will benefit from business-minded people in those positions. And you do own a small business when you're a landlord, right? So you have to be mindful of that. And then there's also this ballot initiative, which whether or not it actually gets posted or not is something to still be determined. But there has been a proposal for rent freezes. And this too can obviously impact all of our people that are on this and our clients. And so we're very mindful of those things. So keep an open mind, stay educated, stay in the know. Like I said, this is too critical for you to think that all will be well and find out later that it may not. So I appreciate everybody joining. I do have a bunch of questions that came in. I'm going to stick with the ones that are going to be more general. I can't necessarily expand upon some of the specifics. But, one owner asked, what is the RAD, BBL, and ERAP? Well, ERAP is the Emergency Rental Assistance Program. And so when residents do fall behind, there are a handful of different resources that they should and could take advantage of to help them catch back up. The basic business license, the BBL, is what you have to have in place to be managing or renting out a property in the District of Columbia. And there's a couple of different aspects of it based on the property that you own. And then the RAD is the Rental Accommodation Division, making sure that you are filing for the rent control exemption
You'd have two things if you're running property. The BBL, you get that first and you use that information to submit your rent registry filing, and that will spit out a certificate. You need both that certificate and the BBL to get into landlord-tenant court.
Yeah. Let's see. Notice non-payment of co-op owners who are not technically tenants. We're not going to expand upon that right now. This is more landlord-tenant situations. But if you are owning a property in a co-op and you are the landlord that are leasing it out, you do need to have a license. Anybody that's renting, it's a single family home, it's a condo, it's a co-op, you're a multi-unit rental building, you need to have a license. Some of those will be required to have a certificate of occupancy, multi-units, but you definitely need to make sure that you have that license. Tenant race and maintenance. Okay, so one anonymous attendee had mentioned that the tenant raised some maintenance concerns, but when we arranged the inspection to do repairs, they did not let our team in to the unit. We have no keys and plan to change the locks when the tenant are adamant of the process. What do we do?
I would say, look, it depends what you're looking at. I know that's an annoying answer from a lawyer, but if it's an emergency, change the lock and go in. Make sure you're giving them a key. You're not changing the locks on the tenant, you're changing them and giving them a key. If it's something, like preventative maintenance or something that's not going to, I would say negatively impact the value of the asset, 30-day notice to cure quit, because it is a breach of lease and it's actually a breach of DC law to refuse access for reasonable purposes during reasonable times. Now, you're giving them 48 hours at least, 48 hours written notice. You're not going at 7 o'clock at night or 7 o'clock in the morning. You're going during business hours, during, on business days, non-holidays. But assuming you're doing all of that and you're still not getting into the unit, I would start a breach of lease process, which is similar to a non-payment of rent process.
Yep. And that goes to the next one about landlord's access to the unit for maintenance and inspections without the tenant's permission. If a tenant reports a maintenance issue, it can be viewed as permission.
Right. Yeah. I suppose the straight answer is no. The law doesn't say the tenant will allow access on 48 hours notice during during business hours, so long as they agree. Now, look, obviously try and work with people. If they're saying you can't come in because I've got a sick kid and he's napping, most people are going to say, okay, we'll reschedule it for a day that works better. Give me something that works. If it goes from reasonable, and you'll know when it crosses the line, but if it goes from, reasonable request to reschedule and it's not an urgent repair, if it crosses from that into habitually rescheduling, not letting you in, then I would say tell them, don't ask when you're going to be coming, and document the fact that you gave the notice. Make sure they know why you're coming. So we're coming to paint and this area needs to be cleared out of furniture or whatever it is, right? Provide some detail. They're entitled to know what's going on because this is where they live. But tell them, don't ask, and then show up prepared to do the work. And then, if it continues, then I think you're looking at a breach of lease process like I just described.
Yeah. Again, document, right?
Yeah. The documentation is important.
Yeah. And so another question is about handling the licensing process. We actually have a in-house processor that is able to help our clients navigate the process from beginning to end. There will be some additional paperwork, there will be some additional fees, but ultimately, yes, we're able to facilitate that in-house now. So for those that are in a position where they need some help, this is a great conversation to start with, and I am more than happy to set some time. You can shoot me an email, give me a call after this, and we'll find an opportunity to talk. Not to mention the fact that we're going to be giving this final end of year promo of a couple months management fees if you sign us on with us before the end of the year.
I see one question, Conrad, that I should address. When I said you can't count on the small landlord exemption, you can if you qualify as a small landlord. You can't count on it if you're not registered as exempt with the city. The issue is that if you're a small landlord, that's great. You will be exempt from rent control, but you've got to get that filing in, and you've got to get a certificate laying out that you are exempt. Because the case law on this basically is that even if you are entitled to an exemption, if you don't do the forms and you don't register as exempt with the city and disclose it to the tenants that you are exempt, you are subject to it. Right. So you have to go through that step in order to what the Office of Administrative Hearings would call perfecting the exemption by getting all the forms done and everything. So hopefully nobody panicked. My point is that you've got to get this licensed up the right way before you perfect your exemption.
Yeah.
Yep.
All right.
Sorry to cut you off, Conrad.
All good. This is a good dynamic. It'll cover in a lot in a very short period of time. So one question was about time limit for vouchers, salary caps. It just so happens that we're going to be talking about that during a next webinar in terms of processing applications, staying fair and compliant for our owners. So I'm going to skip that one for now, and let's see if there's any more. Providing tenants if selling a property, that's going to start getting into the notices because TOPA has essentially been shifted. And running a rooming house is not something we have a ton of, but I'm happy to talk to you, Faith, about that directly if it's something that you wish to get some more guidance on. And why did you say that the owners could not count on the small landlord exemption? Okay, cover.
Just handled. Yeah, and I see Lawrence, I did cause a panic. Yeah, no need to panic so long as you get that rent registry filing in.
Yeah, awesome. Well, I mean, this is a great way to close out the year. I really greatly appreciate you joining us and telling owners about this. I mean, I will have to stress that small housing providers are still the backbone to the industry, to the city, right? And so don't let any of this really discourage you from being able to put your properties into the housing stock. If you're no longer living there, if you don't intend to sell, I mean, there are great quality applicants that are out there that will do all well, pay the rent, take care of your place. It's a matter of finding them. And that's what our team specializes in, to be able to try to make sure that everything that goes into the front end avoids these conversations on the back end, right? And so you still need to market, you still need to show, you still need to maintain the property. You need to be proactive in all of these aspects. And when everything's done right, I mean, 99% of our owners are going to find themselves in a good situation. But you always have to be prepared for stuff like this. So, Brian, thank you so much for expanding upon it. I know that we'll be talking plenty, but I did want to cut us off at the 1 hour mark. And so thank you for your time and happy holidays to all. I'm looking forward to another fun 2026.
Absolutely. Thanks, everybody.